All right. Hey, good morning, good afternoon, wherever you may be. We are back with another edition of our series for business owners. I am your host, 𝗙𝗺 from Wisdom and Wayfinder. We have my co-host, Frank Majorana from Just Works. And we have a special guest with us today, Faye Szakal. I hope I'm pronouncing that correctly, who's a partner and attorney at darn. Okay, I practiced it, and I promise I'm gonna get the names right next time. But you are a partner and attorney at Greenbaum, Rowe, Smith, and Davis. So I just want to make sure that that I get that part right at least. What's the proper way to pronounce it?
So when I was a litigator and I used to go in front of judges, they would all the time look at my last name and be like, "What is this?" And I always told them, do you remember the actor Steven Seagal?
Yep.
My last name is just like Seagal, but with a K sound. So it's Szakal.
Szakal. Okay.
Szakal.
I was nowhere near close.
You were close. You had a sh, but you know, that's okay.
Yeah.
And that's why I didn't chime in. I didn't chime in, Ali. I get nothing. I'm like that sounded okay, but then Faye shook her head. I'm like, well, I got nothing to add.
So yeah.
Nothing to add here.
Listen, if I can pronounce 𝗙𝗵𝗀𝗶𝘀, then I can work on this. This is good.
You'll get it. You'll get it.
Yeah. All right. Well, today we're going to be talking about specifically foundation matters and the business structure basics that every business needs to know. So whether you're starting up, you're in a growth stage, or you are scaling, possibly even thinking about exiting, what are the actual legal structures and documents that you need to have in place for each of those stages and phases of your business? And so Faye's going to jump in and tell us a little bit. And the way that I was thinking that we can kind of maybe order this conversation a little bit was to start at those different phases. So when you're starting up, what does that look like? What are the basics that you need to have in place? And then kind of go through each of those different stages of the things that you might start to think about, whether you're a solo operator, you have a partner, or maybe you're thinking about exiting at some point.
Great. So yeah, I mean, the very first thing that anybody wanting to start a business should think about is what is the form of business that I should be taking? Because, you know, in New Jersey, depending on what structure you choose, you have to file certain paperwork and follow certain procedural steps, right? You can choose to be a corporation, which if you have this idea in mind that later on down the road, you're going to be huge. If you're, for example, a tech startup, oftentimes those apps, you know, they take off and they fly. You might be needing investors later, capital contributions from outside sources. You may want to choose a corporate structure, which is a little bit more complicated, and we'll get to the reasons why for that. But generally, you know, your neighbor, your uncle, your friend across the street, those are the folks that are going to choose the simplest, most or least structured type of entity, which is your limited liability company, your LLC. And a lot of times they start off as a single member LLC and go from there. Like I think you have a single member LLC, right, Ali?
Correct. I am a single member LLC.
Yeah.
Yeah.
So you file your formation documents with the state, and you know, you can file it at 1109 and be an entity by 1111. You know, it's very simple to start it off. There's no requirements in New Jersey that you start with a certain amount of money. It's called capitalization. There's no requirement that an LLC be capitalized, meaning you don't need to open a bank account with $100,000 in order to do it.
Okay.
And so you can have it immediately, have it instantaneously, have it that day. But that doesn't mean that you're done. That doesn't mean that the limited liability of a limited liability company is perfect for you. And there's other things that you should talk about and address pretty quickly once you open your own business.
Yeah, 100%. And I should also add that nothing that we discuss here, please do not take this as legal advice for your specific situation. Make sure that you actually contact your attorney, or if you want to give Faye a call and see if she'll represent you. But do not take anything from this conversation and apply it to your personal life. Do not hold us liable for that or anything like that.
That's an excellent point. You know, don't go experimenting and forming LLCs all day today, because you know, there's annual fees and paperwork and things like that. But it is something that you should contact an attorney regarding your specific needs and your specific situation. And not only an attorney, by the way, I'm only half of the expert equation I think that every small business owner should have and consult. Your accountant is so critical when forming a small business, because even if you're a single member LLC, there are tax implications of being an LLC versus being an S corp, being a regular corporation. And those are all things that, you know, I, as an accountant, I don't know your finances or how you plan on running the business. I'm just an attorney. I don't do numbers, but I work closely with my clients' accountants to make sure that they're making the best decisions for tax purposes.
I do.
Go ahead, Frank.
Along those lines, with smaller businesses, I know you talk a lot about, or you have talked a lot about, like Corporate Transparency Act, and when does, like, so is that applicable to LLCs? And could you kind of share a little bit about what that is?
So not anymore, sort of. So the Corporate Transparency Act was a big deal for a couple of years. It came to be known in 2023, and it was going to be effective January 1st, 2025. And at the time, every single small business in America was going to have to report what was called beneficial owner information to the federal government through a database. And it was particular to small businesses because, you know, there were exemptions. There were 23 exemptions, but basically you had to be a pretty high revenue earning entity in order to qualify for the most commonly applicable exemption. If you were making less than $5 million a year in cash receipts, you were not eligible for that exemption. And a lot of small businesses, even lucrative ones making, you know, 2 to 5 million, don't fall into that category. So for a period of time, all of these LLCs, single member LLCs, multi-member LLCs, were having to report under the Corporate Transparency Act. But last March, the federal government, the Department of Treasury, said, hey, you know what? This is overly burdensome for our small business owners. We're not going to require it anymore. And they put a hold on it. And right now, as it stands, the federal Corporate Transparency Act is only applicable to foreign companies that register to do business in the United States. If you're a United States domestic entity in any of the 50 states or the territories, you do not have to report. You don't even have to report your foreign owners. So that kind of went to the wayside. However, caveat, there is an LLC Act in New York that is specific for New York formed LLCs. And it requires the same reporting of beneficial owner information, which is, you know, if I owned a New York LLC, it would be my name, my personal address, my date of birth. I'd have to upload a copy of my passport and basically identify myself as a citizen of the United States or whatever country I would be a citizen of. But that's only in New York right now. There may be one other state that has a Transparency Act. We do anticipate that a lot of them are going to be, you know, kind of put aside. If the Fed's not collecting not collecting personal information, then the states aren't going to do it.
But it's amazing how quickly that, like, laws change, right? You all of a sudden have a law where it's like, oh, hurry up, everyone get this information. Then it's reminds me of
and you know, I would even argue that, like, I think I don't know if it necessarily changed the law. I mean, there's a provision in the Corporate Transparency Act that allowed Treasury to determine its own regulations with regard to the act. And what Treasury did was basically say, well, we don't like the act that Congress wrote, and so we're going to completely change how we enforce it. I don't know that that's 100% like legally correct, but I'm not a regulator and I'm not an attorney that raises, you know, sua sponte cases against the federal government. So until a congressperson or a senator says, hey, this is wrong, the Department of Treasury is just going to not enforce it as it was originally passed. So.
Well, I filled out my paperwork anyway, so
A lot of people did. There was a deadline,
Yeah.
and you abided by the deadline. I mean, I had clients, there are real estate developers who have
Mhm.
50, 100, 150 LLCs because they place every property they own in a separate holding company. And
Yeah.
those companies don't have a lot of revenue because all they do is hold title to a property, right? I could have my personal home under an LLC and it would have no income every year, but it would own my house.
Mhm.
Those developers that I represent spent weeks filing beneficial ownership information reports. Weeks. 150 LLCs,
Yeah.
weeks. And then boom, done. It didn't count for anything.
It's time and money.
Yeah, but that unfortunately happens, and being in compliance is more important than, I guess the slight waste of time. I don't think that the law necessarily thought about people who owned 150 LLCs being inconvenienced. But it is
They rarely do. Let's be honest.
That's true. That's true. If people who actually practiced law were the lawmakers, it'd be different. It's just like, when the legislature passes laws that affect schools, have teachers give you input on what those laws should look like, because they're the ones boots on the ground experiencing the backlash, so.
That would
But that is the Corporate Transparency Act, and it's dead for now. So we'll see. We'll see if it comes back. I'll keep you posted.
Yeah. Well, you were talking before about it's very easy to get a LLC, but it may not be the right structure for you. Can you explain the difference between like an LLC, an S Corp, a C Corp? Because, again, we saw this a lot with during the pandemic, a lot of people going on Instagram saying, oh, start an LLC today and you can do all these things. And it's like, you're going to send those people to jail because their things are not set up correctly. Like,
right. So an LLC, so corporations have been around forever, hundreds of years. Corporations are the way businesses have been structured for a very long time, where people can invest and own shares. One of my favorite shows was on PBS. It was this show called Poldark, and it was coal miners or iron miners in 1700s Great Britain, right? And the people that funded these mining expeditions were shareholders in corporations that were formed in order to mine this product, right? So corporations go back hundreds of years. LLCs are babies as far as law is concerned. LLCs have only existed as a legal construct in New Jersey since 1994, which makes them younger than I think everybody on this live stream.
Oh my
right?
God, yeah.
Yeah. And LLCs are a state law creation, right? So the federal government, you may not know this, the federal government does not recognize the LLC as a legal structure. What the IRS does is it says, okay, if you're a single member LLC, you don't need to file any separate tax paperwork. You use your owner's social security number, unless you have employees, which we'll put a pin in that, but use your owner's social security number. And when your owner files his or her personal tax return, you just put the LLC income on there with a separate, Form C or whatever it is. Okay. So the federal government, if you look in federal code, there's no reference to limited liability company acts, limited liability companies, because they don't exist under federal code. Instead, you're disregarded. Or if you're a multi-member LLC, if the three of us were to open an LLC together, we're considered a partnership under federal tax code. And we would be taxed as a partnership. Now, partnerships also don't pay separate taxes. So every year, let's say the three of us have our partnership. Our partnership would have to file one tax document. It's a 1065, and the 1065 is just an informational return. All we're giving is the IRS information about what our partnership produced for that year. In addition to that 1065 informational return, each one of us would get a K1, And the K1 tells us what our portion of the profits and losses and any distributions we got from the partnership that year look like. We attach the K1 to our personal tax returns, and that's how the federal government knows that the partnership paid taxes on what it made that year. That's entirely different from a corporation. Corporations, actually, if you are a shareholder in a corporation, the income that that corporation made and gave to you in a dividend is taxed twice, because the corporation files what's called a Form 1120. The 1120 is a corporate tax return. It pays a corporate tax rate on all of the profit that the corporation made that year. Basically, I mean, that's a very basic way to say it, but they pay their corporate tax rate. And then when they've given all of us our dividends as shareholders, we pay tax on the dividends. Okay. So if the corporation made $100,000 in profit that year, at the corporate level, the corporation pays taxes on that $100,000. And then if you $33,000, you $33,000, and me $33,000, we're going to put that on our personal income tax returns as income, and we're going to pay our income tax rate on that $33,000. So the issue with the corporation is everything is taxed twice. It's taxed at the corporate level and at the individual shareholder level. This is why partnerships and LLCs are attractive, because the income is only taxed once. It's only taxed when it reaches the pockets of the individuals who are members or partners.
What's the benefit from the LLC and a partnership? You also can limit some of your exposure, correct? By having that.
Yes, so that's great. That's an excellent way to kind of segue into this part, because the LLC came to be in New Jersey in 1993, 1994, because it blends all of the best components of a corporation and a partnership. So partnerships didn't have limited liability initially. Now there is such a thing as a limited liability partner under the law, limited liability partnership. We can put a pin in that. But they did not have the same limited liability. And in a partnership, in a general partnership, it is still the truth that the partners can be jointly and severally liable, meaning each one of us can be liable for each other for the acts that we do as partners in the partnership. It's pretty complicated. Of course, they'll go after the partnership first, but if the partnership doesn't have enough to pay a judgment award, for example, then individual partners can be liable for that. That's problematic. Small business owners don't want to lose their houses because there was an issue with an employee that did something and resulted in a lawsuit. Okay. So corporations have limited liability. That's why everybody likes a corporation. Corporations have the corporate veil, meaning you can't get at the shareholders absent very specific and nuanced circumstances that can be very, very expensive to prove in a court of law. And so the legislature in the early 90s was like, how can we blend the tax advantages of a partnership, this flow through taxation where you're only taxed once, with the limited liability of a corporation? Corporations, as I said before, can be very, very complicated. You have mandatory meeting requirements under the law. You have mandatory documentation requirements under the law. There's a lot of moving parts. And for your neighbor, your family member, your person across the street, it can be difficult to follow all of those requirements. So the legislature was like, how can we make this easier for small businesses to emerge, have the flow through taxation and the limited liability? And boom, those two things were married and formed the limited liability company. That's the idea. You have flow through taxation, you're only taxed once, and you have limited liability protections.
Yeah.
Oh, by the way, so, but there's issues with limited liability companies, and
there's more.
But that's how the S Corp came to be. So, Ali, you asked me before, what is the difference between a partnership, an LLC, a corporation, and a C Corp and S Corp? So here's the thing. An S Corp isn't actually an entity structure, okay? When you go on the Division of Revenue and Enterprise Services website to form your company, you can form a partnership, a nonprofit, a for-profit, or an LLC. You can't form an S Corp. There's no way to do that. The S
No.
corp is a tax construction. It's a tax election. So you can choose to be an S corp if you're an LLC or a partnership by making an S corp election, which is a tax document that you file with the federal government. And how the reason the S corp came to be is because one of the problems with being an LLC or a partnership is if you're a single member, you have to pay self-employment taxes, or even if you're a multi-member, you have to pay self-employment taxes on the full profit, which can be difficult for if you're a good LLC and you're making $1 million a year, now you have to pay self-employment tax on that $1 million as well as your personal income tax rate on that $1 million. It can turn out to be a lot. So the way you avoid that is you elect to be taxed as an S corp, and one of the primary thresholds for being an S corp is you have to pay yourself a fair salary. So if I have a single member LLC and I choose to be taxed as an S corp, I'm going to give myself a fair salary for an attorney, whatever that might be. And then I will only pay taxes on that salary as long as the IRS says that is a fair salary for an attorney.
Yeah.
And the rest will be my distributions, and I'll just pay my regular tax on that. So it's to circumvent the self-employment tax. That's what an S corp really is. It's not an actual construction.
Faye, when trying to decide which structure to use, is that a conversation with the entrepreneur and their attorney, the entrepreneur and their accountant? Who should they be talking to first to say, what should I do?
100% should be talking to both.
Okay.
Talk to both, because a lot of my advice would be based on where do you see yourself in 5 years, 10 years, 20 years. I know from my experience doing mergers and acquisitions, from my experience dealing with businesses of all sizes, mid-size and extremely large, down to the entrepreneurial level, I know that if you plan on taking in private money later, angel investors or investors of any kind, they typically prefer to see a corporate structure because they like the corporate veil protecting them as, I'm just buying shares. What liability should I ever possibly have? And there's a lot of provisions within the law that are now designed to protect investor shareholders. So as if you're, I've worked with tech startups and app developers. Oftentimes they view needing a lot of fundraising, a lot of sale of shares to make money to fund their application development. I would recommend form as corporations because that is the most attractive to investors. But if that's not your game, if you plan on just being a single person shop for a long time, or maybe down the road, if I get married, I'm going to bring my spouse in or whatever, then forming an LLC is a smart way to go. You avoid some of the problems that partnerships have, unless you're forming specifically a limited liability partnership, which again is typically reserved for like professional people, like Greenbaum is a limited liability partnership. But forming an LLC is typically the easiest if you don't plan on needing a lot of outside investors bringing on that kind of money later on. That's not the same as if you plan on taking loans. If you plan on taking loans, whatever structure you want to do, that's fine. But if you plan on having investors and like long-term people who are feeding you money and you're giving them a return, then typically a corporation is what I would recommend. Going between a partnership or an LLC, or choosing an S corp election, that's a conversation that you would want to have with your accountant as well.
And something in some cases too, your financial advisor is definitely probably involved with that as well, right? You have your entire team that's going to be involved in that. So. Definitely.
And for me, one of the things that I'm really trying to promote after having been practicing this area of law for a bit of time now, is I'm trying to encourage small businesses to have operating agreements or partnership agreements, governance documents Under the law, corporations have to have bylaws, okay, and articles of incorporation. And articles of incorporation have certain mandatory provisions under the law, and bylaws are required under the law. There is no such requirement for an LLC or a partnership. And the default provisions under the law aren't what you think they are. They're not that great. So let me give you an example. The three of us form an LLC, but I'm the boss, I'm the queen, I'm owning 50%. You guys are each getting 25. But you know what? You guys are my friends. You're my friend. I trust you. We don't need an operating agreement. Cool. So we operate and we make good money. Let's say we make $1 million our first year. Well, I own 50%. I'm giving myself 500,000 of the profit allocation. And each of you are getting 250,000 of the profit allocation because you own 25%. That's what we agreed on. Well, under the default provisions of the law, profits are distributed capita, meaning by head, not by percent interest. Under the law, you guys could put your heads together and say, you know what, Faye's screwing us under the law. Under the law, we're entitled to a third each. Let's take her to court.
Let's get that money, Allie.
And
let's get it.
Yeah.
Right. And without that operating agreement that says that we agreed otherwise, I have to go to court before the judge and prove, no, these guys agreed to 25%, but it's 2 against 1 in this case. And at the end of the day, the judge does a piece of paper with a signature on it that says that we agreed to that allocation of 50, 25, 25. Under the law, that judge is probably going to give you your 1/3 each. And I have to, correct my taxes and pay you money, and it's a mess. But that's the default. People don't realize that the default is per head and not by percent interest. So I meet people all the time who are like, oh, I own 10% and my dad owns 90%. Oh, do you have an operating agreement? No. It's just understood. He's my dad. Yeah. Bro, you're entitled to 50% under the law. Like, let's have a conversation. You need to iron some things out.
Does the operating agreement also affect liabilities? So, no. No.
So it doesn't affect liability. The limited liability is a provision under the statute that applies no matter what. Okay. And what you can do in your operating agreement is sort of make exceptions for certain things. There are already exceptions under the law. So if one of us were to commit fraud against the other members or do something that was illegal, then the limited liability protection of the company wouldn't protect that individual. And we can make agreements within the operating agreement that, if, Ali commits some atrocious fraud, that if our company suffers, that he's going to pay damages to the company because of the company suffering, because of his criminal act. But that's, that's stuff that you can put into your operating agreement. The limited liability itself doesn't need to be specified in the operating agreement because it is just part of the law. We put it in there as boilerplate, but it's not a reason. I will say that under the law, another default provision under the law is that every member has equal managerial rights. So even though in our scenario, I own 50% and I want to say I'm the boss, you guys have equal rights under the law if we are using the default provisions. Member managed, all the members have an equal voice. The only way we can circumvent that is in an operating agreement where we identify me as the managing member. And in the operating agreement, you can specify what I can and can't do without the approval of both of you. So things like, I can't go off and sell our company out from under our feet without your approval. I can't take a loan in the company's name for for a certain amount of money without all of your approval. Things like that. But that can only be spelled out in an operating agreement.
Yeah. But I also remember you telling me that even solo members should have an operating agreement for their business as well. Right. And I know sometimes you're thinking, well, I'm working by myself. Why do I need to have an operating agreement? I know what I'm doing.
Okay. Well, here's why. Because look, when you're a business person, you this is your child. This is your baby, that you're in control of this thing, right? And if you create something fabulous, you want to see it continue on beyond you. Under the law, that's not what happens. Under the law, if something were to happen to you, the people who are your beneficiaries, they do not get to take over your company and just keep running it. That's not how it works. Because under the law, as soon as you pass away, you become a dissociated member, which means you're no longer actually a member with any rights of the company. I mean, you are dead, but you're entitled to economic interest. Sorry, that's a little dark, but but your estate also is not a member. Your estate is only entitled to the economic benefit of your company. So when you pass away, your estate does not step into your shoes as the owner of your company, and then your beneficiaries step into your shoes as the owner of your company. No, under the law, your company will, after 90 days without a member, will dissolve, will legally dissolve. So as a single member, you should have an operating agreement because you should lay out your succession plan. When you are incapacitated, if, God forbid, something were to happen and you were to be unable to answer questions, make decisions, or anything regarding your company, you should have somebody designated to have that authority within your operating agreement. And alternatives. If you want somebody to be automatically admitted as a member upon your death so they can immediately take the reins of your company and run it, you should name that person and name in the alternative and keep that as up to date as you would an estate plan when life situations change. Those are the things you need to do. And also, if you're a single member LLC and you plan at any point, you might want to bring on another member, a partner of some kind. That person you bring on is bound by your operating agreement that already exists without even having to sign it. Under the law, they are bound. Now, as an attorney, I recommend you have them sign it, but without even having to sign it, they are automatically bound when they agree to become a member. You can have provisions in there that protect you as the founder of your company. So, Ali, you're a single member LLC. You're going to be huge. 10 years from now.
Yes, I am.
You are 100%. 10 years from now, you may have the opportunity to merge with some crazy, international company, right? But you took on a partner and that partner's like, nah, I don't want to do it. No, we're not doing it. Now your whole life dream, your ambition, this great opportunity is squandered because you took on a partner.
Yeah.
You can avoid a situation like that with an operating agreement that you draft now while you're in 100% control. That includes drag along rights, where for opportunities like that, if they come along, you can force your partner to sell along with you or merge along with you. You can put in things so that you have sort of a much stronger hand in the game in perpetuity because you're the founding member, and you control that now. And it's a beautiful thing.
Yeah.
And rather than think about it when you bring somebody in who's going to fight you on all of those provisions that you want, just put them in there now. It's harder to take them out once they're in.
Yeah, it sounds a lot like, like setting up a power of attorney for yourself.
Yes.
Right. And I think oftentimes people think like, okay, well, they focus mostly on like, okay, if I'm going to die, right, then I need to be thinking about those things. They also don't think about what I've noticed is the long-term incapacitation. What if you get sick, right? What if you wind up in an accident and you're comatose for 90 days or something like that, right? What happens in those regards? And I'm just thinking about, Seamus, who's in our group, some of the work that he does, but then other conversations that I've had with insurance people in the life, health, and disability. Like, how do you replace your income if you're not able to work in the long-term interim time? What do you have set up for your business to make sure that you're both incurring that income, but then somebody can step in and make those decisions, keep the business running while you're incapacitated?
Yeah, you really have to think about who you trust to step into your shoes in those circumstances. And the way to memorialize that is in an operating agreement, even a single member operating agreement. You can protect yourself. You can do succession planning. You can plan for your beneficiaries and keep your company alive. Or if you want your company to dissolve when you pass, you can specify that too.
Can a key employee be named in the operating agreement without necessarily having any ownership? Right? You can
absolutely. So, you know, maybe I want to own an LLC, 100% single member LLC, but I'm a lawyer. I don't have time to run this company. I'm going to enter into an operating agreement with myself, and I'm going to name my key employee as the manager of my company. And I'm going to give that person certain authority to act as an agent of the company in my stead. But I'm also going to reserve in there a lot of oversight where they can't do certain things without my approval or my written consent. But managers of LLCs, people who have that kind of authority, and I'm not talking like manager of a store. I mean like day-to-day operational decisions, like COO type stuff. Managers don't have to be members. They don't have to be members, and you can name them in your operating agreement. And additionally, name how to remove them. All right. Maybe this key employee is great, but needs to take family leave. Okay. And so they're going to stay employed. They're staying on your books as your employee, but they can't manage the day-to-day decision-making of your company anymore. You should remove them as manager and have a mechanism in place to do that within your operating agreement, and a mechanism to appoint somebody else to step into that position. Being the manager and being an employee are not the same thing, but they can be the same. They can be the same person. A manager doesn't have to be a member. Yeah.
Wow, that's a lot. It's great, but it's so much.
There's so much nuance to LLCs. You know, for example, like if we're in a business together and Ali, we don't have an operating agreement, Ali could turn around and sell his 25%, because I'm still only giving you 25. He can turn around and sell to anybody, and that person under the law does not get to be a member of mine and Frank's company. Sorry.
Yeah.
What they get is an economic interest. You can only legally transfer to them your economic right, so your right to a distribution, and you still retain all of the liability as a dissociated member for everything that happened up to the point that you transferred your economic interest. So it's not this cut and dry, like Ali can go and sell to somebody else and they become our partner. Nor could we make a decision to bring somebody in without full consent of all of us that person becomes a partner. It's so complicated. And I know that LegalZoom and LegalShield and AI make everybody think that they can be a lawyer. Like, who needs Faye when I can have AI draft an operating agreement for me in 10 minutes? That operating agreement does not appreciate the nuance of the NJ Revised Uniform Limited Liability Company Act. It doesn't appreciate all of the various scenarios that I've seen play out, and I know case law about, and I know the options and things to avoid hefty consequences later. It's always good to spend the money up front to avoid a hefty legal bill if something goes wrong. Be proactive, not reactive, because proactive services can cost you a couple grand. Reactive services can cost you $500,000.
And it's also,
I mean, it could just cost you your business.
Yeah.
Oh, your entire business, your everything. Yeah, everything you work for.
And like I say, it's also having someone across from you that understands you. Like when we started this conversation about, it's like, where do you want to be in 5 years? What do you like? What's going on in your world? Like, that's important conversations to have. Makes sense. So you look at kind of deciding what type of structure you have, right? You talk about the operating agreement, and let's say you have a partnership. What's kind of the next step of my checking my boxes?
So definitely, you want that operating agreement or partnership agreement. That's going to be a conversation amongst the lawyer, the accountant, and all of the members or partners. And you want to do it while you all like each other and you're all excited about your business, because that's when no, seriously, it's better to make decisions about the what ifs when you like each other. It's like a prenup, right?
Yeah.
It really is. Like, we're about to get married. I love you, I like you, whatever. But what if I hate you? This is what is going to happen. I'm serious. Business divorces can be super ugly and very expensive. So, that's really what you need to do. And once you have that in place, I highly recommend that, business owners, especially in multi-member LLCs, multi-member partnerships, closely held businesses of any kind, you have check-ins, have a meeting, take notes as to what happened, keep them in a binder somewhere. Look at every decision, every important major decision, and think, okay, even though I'm not a corporation, what would a bank want to see to show that we made this decision together, the three of us or five of us, however many, in a unified manner? That might mean writing down meeting minutes once a year. It might mean doing a resolution when you make a major business decision, such as applying for an SBA loan. So many businesses are doing that. And banks that are representing these SBA lenders, they want to see a resolution of all of the members of the LLC authorizing this loan application.
Yeah.
Look, there's no requirement under the LLC Act that certain formalities are followed. That's the beauty of an LLC. It's very simple. There's not a lot of rigor to it. But the more formalities you follow, the more professional you look, the more credibility you have, the easier it is to defend yourself in a situation where somebody is trying to get at you personally for something that is a business litigation. And, the easier it is for lenders to say, oh, okay, this is an authorized action, or this is a legitimate situation here. Nowadays, a lot of banks are requiring operating agreements right at the get to open a bank account of any kind. Having a little bit of formality going forward and keeping those records all in one safe place is what I highly recommend. Make sure that people have access to your operating agreement, that everybody has a copy who is a member, that your accountant has a copy, that your lawyer has a copy, your financial advisor has a copy. Keep a copy in a safe, take a look at it, read it once a year, make sure it's up to date, and think about the future. Think about those kinds of things as you operate on a day-to-day basis.
Yeah, I'm scheduled to review the operating agreement and documents that I set up for 𝗏𝗏 Wayfinder, which is separate from the agency that I had before, 𝗏𝗏 Marketing Design Studio. I set those two businesses up under different entities, but like you said, you said it really great in terms of make these decisions when you like each other. Yeah. Even as a solo business, like, make these decisions when you are the most excited and hopeful, and you haven't really gone through, through the crap yet. Because that'll really, you want that to be the thing that guides you, right? And you also want to protect yourself from those days when things are just really shitty and you're getting your teeth kicked in and you're thinking about throwing it all in, right? Like, walking away from the business. Making sure that you have those documents and reviewing them on a regular basis really keeps you on track for the vision for the whole reason that you started this business in the first place.
Yeah, just have an understanding of, what the outside world is seeing when they look at your business.
Yes.
It's super important for just legitimacy. And nowadays with, the internet and the type of society that we live in, a small business in, Neptune, New Jersey can touch people in 100 countries or all 50 states or everywhere in the world. Yep. The reach is so broad that your professionalism and how you choose to set yourself up becomes even more important. I like to tell people all the time, limited liability is, it's only as good as those words are, right? Like anybody can sue anybody for anything. Everyone asks me all the time, hey, do I have a suit here? And I'm like, anybody can sue anybody for anything. And just because the other person is wrong and making a claim that's nonsense doesn't mean that you're not going to have to pay to defend yourself. And it doesn't mean that you're going to get your legal fees back when the whole thing is said and done. So the more things you can do to protect yourself, the more risk adverse you can be, the more you can set up agreements with your partners now while you like each other, before you wind up in a place where you have to fight it out in court. Do it. It just makes more sense. It's just the risk adverse thing to do. So, I love operating events. I could talk about them all day. I love working with small business owners who realize, like, oh, wait a minute, I didn't realize I needed one. Can you tell me what I should put in it? Like, I'm happy to talk to anybody. It's just so important to be risk adverse in a world like this where anything can happen. It's important to be risk adverse.
Yeah. Well, I don't even see it as like risk adverse. I see it as being the most optimistic that you can possibly be, for your business. Like, I'm going to set these things up because my business is going to do so well that it is going to attract people that might try to, sue me for, strange reasons, or because my business is going to grow and expand. These are things that I need to be thinking about now so that it's easier in the future.
Like before, you were talking about long-term care, right?
Yeah.
It's so successful that, someone needs to be getting these profits. Someone needs to be benefiting from this, and this shouldn't close just because I'm gone. Absolutely.
Yes.
I couldn't agree with that more. That's awesome.
Ali, one thing you said, I think last time I saw you, you were talking about, don't be like the gatekeeper of your company and your company's operations. Like, there needs to be an understanding of how to run your business that you can hand to somebody for when you're not there. And I think a lot of single member LLCs, a lot of solos, they're so in it and so engaged and so enthusiastic that they don't think about like that documentation. That's the same way with your operating agreement, your certificate of formation, your, if you do an S election, all of those documents should be in one place. And, operational stuff should be with that as well.
100%.
Like, you should not be your operational system. Absolutely. Yeah. That's wonderful.
Absolutely. You should not be your own operation system. That's a perfect way to put it.
I'm going to steal that. I'm going to steal that line.
No problem.
I'll give you both 25% of whatever goes in.
That's so generous. Thanks. I do copyright. So, and just as an aside, another thing that in 1994, and even in 2012, when the revised Uniform Limited Liability Company Act came out, they didn't contemplate, the type of world that we live in, and this idea that, intellectual property is a huge component. There is an element in the law that says the property of the company belongs to the company and not the members. The property of a partnership belongs to the partnership and not the individual partners. But does that include intellectual property? Does that include, if I'm at work and I come up with a great idea and the company decides not to go with it, and then I decide to sell my interest and leave, does that idea belong to me or does it stay with the company? These are the types of things, depending on what area of business you're in, you can make considerations for within your operating agreement. Competition. The three of us may have a company together, but we're also doing our own thing. Am I obligated to bring every opportunity to the company, or can I keep it for myself? Restrictive covenants. What happens if I decide to sell off my portion or Frank sells off his portion? Can we compete and open up a store next door? These are things that are not included in the law. And as friends, you're like, I'll never hurt you. I'll never mess with you. I'll never ruin our company. But at some point, things break up. Problems happen. Issues arise, and you can deal with them while you like each other, and you'll never stab each other in the back before you actually stab each other in the back and wind up in court.
Yeah, but just don't give yourselves opportunities to pick up a knife, and that's pretty much what this sounds like.
Exactly.
This might be a silly question, Faye, but how do you help your clients? As laws change all the time, right? Constantly, rules and change. How do you stay on top of when things are changing, which clients they're affecting, and knowing how to reach out to them.
Right. Well, the good thing is that corporate law, the LLC Act, for example, those types of things don't change substantially very often.
Okay.
So the revised Uniform Limited Liability Company Act was enacted in 2012. It went into effect 2013, and it became applicable to every LLC in 2014. It has not changed since 2014 in any really substantial manner. And when things like that do happen, they take time. Laws don't change overnight. So lawyers, especially lawyers in large practices where there are people who are, designated to pay attention to that kind of stuff, will see that there's a significant change in the law. And typically what we do is we send out a client alert, or, if anybody signs up for our newsletter, they'll receive our newsletter, and we'll put a bulletin out that says, this is what the law used to say. This is what the law says now. If you think this applies to you, contact Faye, and she'll walk you through it and let you know what you have to do to become compliant. But since nothing happens, overnight in law, there's usually enough lead time for us to think about our clientele, who might be affected, and reach out with enough time for them to make the necessary changes.
Do you still recommend at least an annual review with your team?
Yeah, and it literally could be a 3.5 to 5 minute phone call with your attorney, just checking in. Having an attorney, one of the things now that I'm working on and that a lot of small businesses are looking for is this concept of an outside general counsel, a fractional general counsel, somebody that can be their legal advisor for their entity on a more permanent basis. And whether that's a fixed fee structure or just an hourly rate structure, contacting an attorney and saying, hey, I don't have anything going on right now, but could you take a look at my operating agreement? Let me know what I need to change. Sure. That starts our relationship. And then keeping me in your Rolodex or in your cell phone as that person to call, having an ongoing sort of open file with an attorney, a retainer agreement, a fractional GC is a good idea, because you should, just like you do with your accountant, you see them once a year, you should consult your attorney once a year and just be like, hey, this is where my company is. This is where I see it going in the next 12 months. What do I need to do to make that happen? I always encourage my clients. I have a lot more clients that are coming in these early phases and wanting a sort of fractional general counsel relationship. And I always say to them, what do you look like a year from now? What are you thinking about for 5 years, 10 years? What is the plan? Because there's agreements along the way that I would encourage them to enter into. Even, Ali, before you said you have 2 entities, if those entities do any business together, they should still have a contract between them, even though you'd be signing on behalf of both entities as a single member of both entities. And it was, why do I need an agreement with myself? The entities are not you. You are not the entities. So the entities should have a contractual agreement. And these are the types of things that,
let me add that to the list.
And Ali, if you disagree, then Faye can mediate for you.
There you go. And Frank, that's a beautiful word to end on. All of these things, having these agreements in place are great ways to avoid disputes. Also, within your agreement, put in a mediation, a dispute resolution provision to avoid winding up in court, because mediation is much cheaper than litigating. Arbitrating is somewhat cheaper than litigating, and litigation should really be the course of last resort when you're in a business relationship. So there's no requirement under the default provisions of the law that require mediation or arbitration or even, good faith dispute resolution. You can go straight to litigating. Put that in your agreement that, first we're going to sit down and talk about it. Second, we're going to consult our advisors. Third, we'll go to mediation. Fourth, we'll go to arbitration. And you can make arbitration binding or preserve the right to go to court.
Yeah.
So lots to think about, but call a lawyer today.
This is awesome.
Yeah, I think we definitely need to have you back for another conversation. So we'll check our schedules and get that working, because I think there's so much even more that we can just dive into this conversation in terms of the different places that somebody wants to be in their vision in their business. And I think I said it when we were at lunch last week. It's like, you're going to exit your business one way or the other. How you do that, how easily you do that, how easy it is for everyone else involved that is no longer, that is still part of the business and the life that you've built, really depends on these documents and what you created today. So yeah, it really is important to think about that.
For sure. And, again, like I said, nowadays, I know that starting a business or being a small business is tough, that money can be difficult and tight. But a smaller investment up front will save you a lot of money dealing with problems in the back end. For an estate, even, God forbid anything were to happen to you and your estate is left dealing with the fallout of you not having an operating agreement, that costs your beneficiaries money that they have to pay the estate administrator to handle resolving the problem that you could have cut off at the pass. So, spend a little bit up front to save a hefty amount at the back end is just always advisable.
Awesome.
I'd be happy to come back, fellas. I really enjoy talking about this kind of stuff and just encouraging people to talk to an attorney. We're not out to get you. We don't bite. I just want to help and make sure that you're doing things the correct way.
It's fantastic.
Yeah.
It's awesome.
Yeah. Thanks, Faye.
Nice.
It's fantastic, as I like to always say.
I love it.
We're ending on that note, Dolly.
Yeah. In the operating agreement, Frank.
That is fantastic.
I get to make a corny joke.
I love it. No, it's great. It's great. Thank you so much, Faye.
Thank you guys so much.
That's awesome.
It's a lot of fun. Thanks, guys.
Yes, and thank you everyone that tuned in, left comments. We appreciate it. And yeah, we'll be back for the next one. We'll keep you tuned.
Thanks, everybody.